Hello, everyone. My name is Jennifer Ellis. I'm an attorney out of the Philadelphia area. I focus on legal ethics and sort of complex legal issues, especially dealing with online discovery and things of that nature. I've been asked by your professor to talk with you about social media and its impact on the practice of law. So I'm specifically going to speak to you about a few things related to use of social media in litigation. The first issue is why social media matters. Then I'm going to go into some ethical issues. Ethics are a huge issue for lawyers. We have special ethical rules that we have to follow. And then I'm going to talk to you about advising your clients. I'm going to talk about how you research it, social media, and how you use that evidence in court. And then, of course, I'll answer your questions as we go through the following week. So these slides are actually for an hour long or so presentation that I do. I kept them intact because I want you to be able to see the information and ask me questions on everything as opposed to just the things I'm going to quickly go through in the next 29 minutes. So the first question is, why does social media matter? Well, you guys know why it matters. It matters because so many people are using it. And in using social media, a lot of people have the tendency to provide more detailed information than they might provide their lawyers, or sometimes they'll even provide opposite information from what they provide their lawyers. I hate to say that people lie, but sometimes they do, or other times they just don't really understand what you're asking. So what happens is they'll tell you one thing, they'll tell the court one thing, and they'll put something very, very harmful on social media. Or their friends and family will put something harmful on social media. For example, they might say, well, I can't run. I can barely walk. I can't leave the house. And then there's video of them dancing on a bar placed on YouTube. Obviously, that's a problem. So, the first thing you need to understand is that we as lawyers have ethical rules, and we have to follow those rules. And these ethical rules are not the same as ethics for your average person. They're actually written out rules that we have to obey, and they have cases interpreting them. And one of the rules is competence. And this, of course, one of the first rules. And it means you have to be competent in your practice of law. And included in that, for most states, and if not all states, is that you have to be competent in the use of technology. And you have to understand the risks and the benefits, and you have to mitigate those risks. What that means is, as lawyers, we need to understand the use of technology in the practice of law, both in terms of what technology is required to use for practice overall, email, computers, the internet, legal research, and what might be required for a specific practice area. So, different practice areas that might have different technology that you ought to use. So, in this case, we're talking about social media. Well, social media has become very, very important in the practice of law for the reasons that I've said. People are using it, businesses are using it, everybody is using it. So, as a result, there's evidence out there. And if you fail to grab that evidence, whether it helps you or hurts you, whether it helps the other side or hurts the other side, that's a problem. So you need to be a competent lawyer, be able to find this evidence and to use it appropriately in court. The first thing is to advise our clients. When a client walks through the door, we need to talk with them about their web use. What are you using? What are you doing? What's going on? And you have to talk with them about how online content, if seen by the opposing side, can be harmful to their cases. I have seen social media content destroy cases out there because it's just been the so opposite of what people have claimed. Now, I'm not saying they've destroyed my cases. What I'm saying is, in performing legal research, you'll find there are myriad cases in which social media has become a big issue over which people argue, over which lawyers are arguing, and that turns into a serious problem because it can damage cases very, very badly. It's best if they stop using social media. Unfortunately, most of them won't do that because they're just kind of addicted to it, like we all are. And you want to talk with them about discovery. What is discovery? How it can impact the case. For your purposes, discovery is finding out the stuff that's relevant to the case and then seeking to admit it into court before the jury, broadly speaking. So, one of the things we talk about is what's relevant. In order to get evidence into court, it has to be relevant. But in order just to get to discovery, you can get a lot broader. And what's relevant for discovery is very, very broad. And that means that opposing counsel can get permission to look at a lot of stuff. So if opposing counsel is able to see harmful stuff in your social media account, they're going to try to use that. And often they'll be able to. So there have been cases, for example, there's one famous case where a woman had been injured, her elbow had been injured in a car accident, and she had a scar across her forehead that defaced her, made her look not so good anymore. And she posted a lot of pictures on Twitter where she was holding this huge pocketbook and talking about how wonderful her life was and how she was actually starting to like her scar. That's a nightmare for a plaintiff attorney because juries, they need to see the negative impact of things on your life. And here, the lawyer on the in the plaintiff side was completely unprepared when the defense attorney came into court and showed all these images and these tweets, and this caused the verdict, which was still in the plaintiff's favor, to be much lower than it ought to have been because she was a hairdresser. She was never going to be able to work again, and she should have received a substantial verdict, but she didn't. And that's because, in my opinion, the lawyer didn't discuss these issues with the client because the lawyer probably didn't even know at this point in time, because it was years ago, that social media really could impact what was happening with the client. So we see these sorts of things. And that's not to criticize the lawyer in that case. It was early enough at that point that it was very easy for one side just not to be aware of social media and the impact it had on the case. But nowadays, there's really no excuse not to be prepared. You want to educate your clients on privacy settings. You also want to tell them not to delete stuff. There's something called spoliation, and spoliation is destruction of evidence. Deleting content from social media is spoliation. Now, there are guidance opinions, and these are opinions from ethics boards that say it's okay to delete the content as long as you preserve it properly in the first place. So we always tell our clients, let us preserve it for you. And that way we can be sure to produce it during discovery if we're required to do so. And the reason we do this, one, is to protect our clients, but it's also to protect ourselves, because if we ever become accused of encouraging our clients to destroy evidence, that can cause very serious consequences for us as lawyers. So how do we get the content? Well, the first thing you need to know is you have to obey the law. It's not as easy to get social media content as it is to get cases off Lexis and Westlaw because of privacy settings. And there are a bunch of laws surrounding inappropriate interception or access of computers and electronic communications. Now, I'm in Pennsylvania, and this is one of our laws. And as you can see, it's pretty serious. It's a felony. And breaking into someone's account, even if you know the password, but you are exceeding authority of what you were told you were allowed to do with that password, is a crime. And if, as a lawyer, you take that content and you try to use it in court, now you yourself have committed a crime. So it's really very important to understand that how you access this data and how you access how your client accesses the data really does matter. We see this a lot in spouses. One spouse will guess the password of the other spouse and log into the account and start accessing stuff. That's illegal. It's simply not permissible. There are times when it's perfectly acceptable for spouses to look at each other's stuff. If they've chosen to share the password and freely given access to each other's accounts, then they're fine to look. However, if the spouse then changes the password and the other spouse now guesses what the new password is, that's not okay. There are appropriate ways to access and there's inappropriate ways to access. Now, sometimes people say, well, why can't I just subpoena the content? And subpoena means that a court orders someone or something, a business, Facebook say, to do something. In this case, if you subpoena Facebook to deliver content of an account, of somebody else's account, in a civil case, they will not cooperate because they claim it violates something called the Stored Communications Act. That doesn't mean we don't ask, we'll try, but generally they don't cooperate. They do cooperate with the government in cases when they have an appropriate subpoena from a judge. Now, they will cooperate in subpoenas for ownership, and that can matter because you have to prove or try to prove as best you can that the person owned this account and posted the information. Because as you know, other people can make up accounts and say, I'm person A. You could make up an account and say you're Jennifer Ellis. You could steal my photos, you could steal my content, but that doesn't mean obviously that I wrote it. So now we have to prove that Jennifer Ellis actually wrote whatever this post is that we want to introduce in court. So that's where it comes up. So how do we do this? Well, again, it's unlike traditional research because of the privacy settings, although some people forget to set their privacy settings correctly, and that can be helpful to you. The first thing to remember is that we have these ethical rules. I'm not going to go through them all, obviously. You can look up the model rules, the ABA model rules, and take a look at them. But they include you cannot communicate with a represented party on the other side, you cannot pretend to be somebody you're not, and you can't connect with jurors, although you can research them. So you can research, but there are rules surrounding what you can do. It's fine to review whatever is publicly available. And it's fine to review what legitimately connected people can see. What's legitimately connected? Well, say you have an adult child, and the adult child is connected to the husband and provides the information to the wife. That's okay. They're legitimately connected. Employees sometimes can have different relationships. They might be you have to be careful with employees. But again, I'm not going to go into details, but understand that sometimes employees can be at a level that they're actually the represented client. And remember, I just said you cannot communicate with the represented client. So what's the process? Well, first we do what's called a litigation hold. A litigation hold is telling the opposing side, don't delete anything relevant to this case. If they do, now they have a problem. So the process I take, it's what we call a 3 or 4 pronged approach. We gather whatever data we can about the person through whatever means. I might ask the right questions in using several tools that attorneys have available to them through the discovery process. I will look on Google. I will ask my client. I'll ask witnesses. I'll locate the accounts. I review the accounts, whatever information I can appropriately preserve. I preserve the data and I verify the information. So we're gathering names, email addresses, sites, links to accounts, everything we can think of. That's what we're going to go and get. One of the things that is important to remember when you're searching to find somebody is that Google can be very useful, but it can also give you too many results. So you have to narrow them down. And I use myself as an example because I don't like to embarrass anybody else. So here I am. We've Googled Jennifer Ellis. Now, Jennifer Ellis happens to be a very common name. And when I Google myself, I come up with 1, 2, 3, 4, 5, 6 results. However, if I Google Jennifer Ellis and I add the letters ESQ, short for Esquire, as you can see, I've got more stuff. I've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 things. So what you learn is you learn to narrow the search by adding additional terms to obtain more detailed and useful results. But you don't want to narrow it too much. And I'm sure Professor Collins will discuss these sorts of things about researching with you. Then you're going to review the account. You access what you can ethically and legally access. For example, here's Facebook. So on Facebook, there are privacy controls. You know that. Your friends can see a lot, but you can limit what specific friends can see, and the public can only see what the owner of the account allows. So this is my dog, Curtis. And yes, he has a Facebook account. And as you can see, Curtis, it looks like he doesn't post much when we look at it this way, where we're not friends, right? You know this. But once we're friends, now you can see how much more we can see. So it matters, obviously, whether you're friends, whether you're not friends. The first was pretty useless. The second wasn't. Now, the other thing that's really interesting is tagging people. A lot of people don't understand the tagging, but it really does cause a lot of trouble because people will tag businesses and then the business will see it, or they might tag a friend and then the friends of the friends can see it. And if you were in the car with the friend of the friend, now that person can see your posts. It can cause all sorts of issues. Of course, you know, or maybe you don't, that the post has to be public by a friend or by a friend of a friend who tagged you so that you can see the post. Otherwise, you're not going to be able to see it. Now, as I said, Facebook will only provide basic subscriber information unless you can get it another way, and then they won't even give you that. So sometimes what we'll try to do is force somebody to download the entire account and then subpoena it and see if we can get it. And of course, it won't include any of the deleted data, as you know. And there's so many other sites. We could look at Snapchat, which, as you know, the videos and pictures disappear, but you can always grab a screenshot. This is Millie, and that's another way to preserve it. So what I do is if somebody's using Snapchat, I'll ask them, did you save photos on your phone? I'll try to get the phone. You'll ask them, to whom did you send the photos? Maybe you can get them from them. There's all sorts of ways to get stuff. You can't just focus on the internet itself. You can't just focus on the person itself. Sometimes you have to go broader and see what you can get. So let's say we've got the information. Now we have to verify it. I spoke a little bit earlier about how there are issues related to fake accounts. And authentication of social media evidence, which I'll get into, is really the biggest problem in terms of getting it into court when you want to use it as evidence. So you have to be able to show whether the account belonged to the person you were seeking. So you compare what you know about the person. You look at the pictures. You look at email addresses. You use other details to see if you can identify that the account that you're looking at was actually created by that person. And then, of course, you have to get into the issue of whether the person actually wrote that specific post, which is a whole nother issue, which we'll get into. So we have to preserve the data. Now, it's not so easy to preserve the data as you might think. A lot of people will just say, "Oh, I'll just print the screen," or "I'll just take a snap of the page." I'll do a screen grab. That's not how evidence works in court. So there are a couple things to keep in mind. One is you need to have another person do the evidence preservation, because if you do the evidence preservation as the lawyer and there becomes a question as to who owns that account and who actually posted it, now you're going to be a witness in your own case and you're going to have to be removed from it. So you want to get a third party to do it. And there's a lot of different ways. Like I said, some people think, well, I'll just do a shot of it, or I'll just print it out. Well, if you print it out, it never looks right. And a screenshot is not really it's not very valid. It's just something that could have been altered. You could alter a screenshot very easily, as you probably know. So that's a problem. And some courts are still letting printouts and screenshots in, because this is still relatively new to many courts and they're willing to accept this sort of thing. And they're especially willing to accept it if the opposing party doesn't deny that it's theirs. But as you get into more complex cases, as more and more time passes, what happens is that the courts are looking for more exact, more secure information. And what we're seeing now is tools. This tool, Page Vault, is a very popular service. It's a monthly service. It's not too expensive. And what it does is it captures websites or individual pages and it provides documentation showing that you haven't altered it. Because what it does is it preserves the metadata. Metadata is data hidden within data that provides surrounding information to it. It provides the date, the time that you took it. It gives you exact copies, and it maintains a chain of custody because it's stored up on the server of Page Vault. It's not stored locally, and they'll provide an affidavit to support that information. Another very popular tool these days is called X1 Social Discovery. You actually perform the search and you collect it, but it still includes metadata, location data, and other information, which can help with authentication. It's desktop software that you can use. Then there's X1 Distributed Discovery. They do access across the entire web, so they're good for webmail accounts. They create searchable index, so they help you explore their data. Of course, there's self-preservation. When I do this, which I do sometimes, I do something like I'm doing now for you. I speak about what I'm doing. I I do screen captures using Snagit as I'm going, and I'm showing everything I'm doing as I'm going it. And that way, if I need to testify, I can. But I don't do this in my own case. I have 14 lawyers in my firm, including myself. So if somebody has a several $1 million case, it's worth taking me off whatever else I'm doing um, to do this kind of preservation, and then I can testify in court if necessary. But frankly, it's all the better to hire an expert when you have a really high end case, because that expert is a neutral party. They're going to work with you to identify whatever you need. They're going to help you do any searches you might need to search. They'll label the evidence. They'll maintain the chain of custody, and they'll provide information about the capture process, and they can testify as an expert. So sometimes that's the best way to go, especially with your higher end cases. Now let's talk about the case law. Could you find access to the account? Can you get access to the account? When you seek for discovery, when you ask for permission to get into the account beyond what you can just see broadly on your own, in other words, you're asking for the whole account to be downloaded, or you are asking for the password to the account. Frankly, you're better asking for the whole account to be downloaded, by the way, because if you ask for the password to the account, now there's no proof that you didn't alter the account when you got in there. But so asking for the account to be downloaded, what you're going to have to do to get discovery granted is to show that there's contradictory information in the appropriately accessed account. Well, what does that mean? We had a case out of Lancaster, Pennsylvania, which is where the Amish are, not too far from here. And the person claimed an inability to do a number of things. Well, they had a profile picture or a cover photo on Facebook, which, as you know, is publicly available, and it showed a shot of the person in the snow running around. And the person claimed, well, it was a different time period. It was before I got injured. Well, here in Pennsylvania, our inspection stickers for our cars are different colors based on the year. And the law firm on the opposing side said the color of that inspection sticker means that this was after you were hurt. And in that case, the judge decided to use an expert to look through the account and find relevant information. But in most cases, if you can show that there's contradictory information to what the party is claiming, you can get discovery, i.e., access to the account. If you cannot show contradictory information, the judges are not going to let you go on a fishing expedition. So as a result, it's very, very unlikely that you will be provided with the access to the account. Now, where have we seen lawyers get in trouble? Remember I told you there's something called spoliation? When you destroy evidence, one thing the judge can do is order an adverse inference to the jury. An adverse inference means you are telling the jury you can assume that the person destroyed the evidence because it was harmful. And you can imagine if you put that in a jury's mind, that's no good. Because often the reality of the negative information that you sought to hide is less damaging than what the jury will imagine. When I talked about lawyers getting in trouble, this is the first case where a lawyer really got in trouble for destruction of evidence. In this case, a very well-respected lawyer told his client to clean up his Facebook account. Then they hid the Facebook account and I believe lied about whether it existed. Now, this was a very successful case, but in the end, the lawyer had to pay around $500,000 in sanction and the client about $200,000 in sanction. The lawyer got his license suspended for a very, very long time, and his career is over. Another area where we see trouble is when people friend represented parties. Here we have a case where the paralegal friended the represented party. The lawyers claimed, well, we didn't understand the technology and we didn't tell the paralegal to do it. Well, the way it works is for lawyers is we are responsible for controlling all the people who work for us. We have to make sure they don't violate the ethical rules. And if they do, we're responsible. And the claim that they didn't understand how it works didn't matter because, as I told you, we have to know how technology that we use works. So these folks are going to get in trouble. Whether it's public trouble or private trouble, I can't say. We also had a young man who was a prosecutor who lied when he friended some witnesses, and that caused a lot of trouble for him. He lost his job, and in the meanwhile, they had to send the case out to an outside prosecutor to deal with it. So there's just no lying. That's a serious problem. So using it as evidence. The broad standard for admission of evidence in a case is it has to be relevant, it has to be more probative or more useful than it is prejudicial. It can't be hearsay. Hearsay is things like, well, this person said it to this person. That's generally hearsay, and that person may have said it to your witness, but that's still hearsay. There are exceptions sometimes, though. And then authentication. And authentication is the biggest issue. These are some of the cases that are out there involving social media and relevance. Here, the plaintiff wanted to prevent introduction of Facebook posts, and the post showed the plaintiff engaged in physically taxing activities after she had claimed to be injured. So, of course, it was admitted as relevant. Authentication, it's a huge issue. And there are two broad standards that are developing around the country. Most of the country are using what we call the Texas standard, which says the judge is essentially the gatekeeper. If you can show the judge through extrinsic evidence, circumstantial evidence, that the person wrote the post, then it can be admitted, assuming everything else is okay, irrelevance and not hearsay and so on and so forth. The Maryland standard actually wanted more direct evidence, which is very problematic given the way social media works. So they wanted forensic evidence and this kind of evidence and that kind of evidence, which kind of showed me that maybe it wasn't explained to them very well how social media works in the court. So it'd be interesting to see if this standard gets applied anywhere else. But most people are using the Texas standard, including the Third Circuit, which is where Pennsylvania is. In this case, they said that social media evidence is not self-authenticating. In other words, just because you get a certificate from Facebook, and this was a criminal case, so they were able to get content. Just because you get a certificate from Facebook does not mean the person you say wrote the post wrote the post. You have to show somehow that it's more likely than not that the person wrote the post. Now, in this case, because it was a criminal case, they were actually able to get the content from Facebook itself, which made it more likely that the person wrote it. But even more so, they had witnesses who could support that it was more likely than not that the defendant wrote it. And then the certificate from Facebook was additional evidence. So in the end, what the court wanted to see was enough evidence to make it very, very likely, or more likely than not, that the person against whom they wanted to admit the evidence did in fact write it, and then you leave it up to the jury whether it was that person. So in a civil case, you're going to ask appropriate cases during the interrogatories, during deposition, and you're going to narrow the person down, and then you're going to get to them to admit they wrote the content. In a criminal case, it's a little more difficult because the person may never get on the stand, and it may become more difficult to ask the questions to prove whether the person wrote it. Social media matters at post-trial too. Most civil cases, if they settle, they have a confidentiality agreement of some kind. And this particular case got destroyed. The daughter of the client posted that the school name is officially paying for her vacation to Europe this summer. She posted that on Facebook, and that resulted in it being a breach of confidentiality. So the court would not enforce the settlement agreement. So this is another point at which you have to talk to your clients. You have to say to them, it's not okay to be talking about your case or this stuff on social media, and you have to tell them to tell their family as well, or you talk to their family. And you have to just make them understand you can destroy your own settlement. And so this is when you're going back to the whole CYA, you're going to make sure that nobody is going to be discussing these settlements. So that's our 29 minutes and 15 seconds. So I will sum it up by saying it can be very challenging to find the data. It's not always easy to preserve it. And it's extremely difficult to authenticate social media data to the extent that you can get a court to let it in. But with this evolving area of the law and the evolving technology that is out there, it is getting a little bit easier to find this stuff. And it's getting a little bit more helpful to those of us who are searching around in social media to get the evidence we need to protect our clients, or to go after the other side, or whatever it is we're doing. You just have to remember to obey the ethical rules and obey the law in your efforts to find the data. I hope you found this useful. I look forward